Hi, my name is Cullen, and I'm a personal injury attorney in Winter Park, Florida. When a personal injury case cannot be resolved amicably, many times we have to file lawsuits on behalf of our clients in order to protect their legal rights. The conduct of any lawsuit is governed by certain rules, and in Florida, those rules are called the Florida Rules of Civil Procedure. In federal court cases, they are governed by the Federal Rules of Civil Procedure, and most states' rules of civil procedure are very similar to the federal rules. A lot of people have probably heard the term motion used when people discuss lawsuits. So I thought I would take a few minutes to discuss in this video what a motion is, how it works, and how the motions are typically used in civil lawsuits. In Florida, motions are typically used by parties when they want a judge to rule on something or when they want something to happen in a case. Motions can be verbal or oral, but most of the time motions are written, so they're in the form of a document that gets filed with the court. Surprisingly, there are very few rules about what kinds of motions parties can make and what form those motions can take. The kind of motions that we typically see in personal injury cases might be motions to dismiss, or motions to compel, or motions for extensions of time, or even motions for summary judgment. Once a motion gets filed, the parties usually go about setting up a hearing time. And a hearing is a time that the parties have in front of the judge where each side gets to argue its case and tries to convince the judge to either grant or deny the motion. The judge also has an opportunity to hear everything that the parties have to say, as well as asking questions of his or her own so that he or she can more fully understand what the issues are. And then at the completion or at the conclusion of the hearing, then the judge will typically rule on the motion, and he will either grant it or deny it, either wholly or in part. And at the conclusion of the hearing, typically the judges will issue written orders, which is a sort of a documentation of the judge's findings or the justifications for his ruling in a document that the parties can then use to figure out how they're going to comply with the order, or even sometimes take it up on appeal. So many times when parties are setting up a hearing time, the parties are also engaged in negotiations over whatever the issue the motion's about. So for example, if the motion is about some sort of extension of time in a case, then maybe the lawyers will get together on the phone and talk about the extension. And in many, many cases, particularly if the lawyers are experienced and do this kind of work a lot, the lawyers will just agree to an extension of a certain amount of time. Once the parties have reached an agreement on an issue, normally they will either draft what's called either a stipulation or an agreed order that they can send over to the judge, and the judge will sign it, and it becomes and has the same effect as a judge ruling on an order or ruling on an issue and issuing an order, but this is an order that's already been agreed to by the parties. Of course, the courts really like it when the parties can work things out, and so that the judges don't have to hear argument and make decisions, and it typically makes cases move along much, much faster. As I said earlier, motions can be used in a wide variety of ways to accomplish a wide variety of objectives. So if you have any questions about motions and how they're used in civil cases, and particularly personal injury cases, please reach out to us. We love to answer questions. All you have to do is call us at 407-254-4901. You can text us at 407-644-4444, or you can even reach us through the Facebook Messenger app.